We're joined in this portion of our program on the fan 101.9 FM and on the Odyssey app. Welcome to our program on Sunday mornings. I'm Bob Salter. And along after 7 this morning, it's Rick Wolf with the Sports Edge program. Always an interesting listen on that program. We're joined by a guest who had spoken with us not that long ago, actually. Had a really good discussion then. Some interesting feedback from some of the people listening to us who enjoyed the discussion as well. Altagracia Pierre Outerbridge is the founder, owner of the New York City-based law firm, Outerbridge Law PC. And her practice is focused on landlord-tenant litigation and transactional matters, as well as immigration cases. She has over a decade of experience litigating in Supreme Housing Court. And she's talked with us before on our program about some of her background. She also had talked with us about some insights about some of the things that have gone on in Haiti as well, too. First of all, it's nice to have you join us again on our program.
Thank you. Thank you, Mr. Salter. Thank you, Bob, for having me.
In beginning this discussion, I always like to assume that for people who are joining us, there are those who heard you talk before, and there are those who did not. This area of law that you've gone into, how did you get into this field?
As I say, it's usually by it's serendipity, right? You get out of law school. Some of us get out of law school, know exactly what they want to do. Some of us get out and we just want to practice law and we need a job. So I went from, I thought I was going to be a labor lawyer. I was very much into unions. I still am very much into unions and labor and employment. And from there, my supervisor, my boss, a very lovely woman, a partner at the firm, says, "Hey, I think I have a job for you somewhere else. I think I can get you an interview somewhere else." And I got into housing. That was 12 years ago. And I'm still here.
Mm-hmm. With this field, because you have an interesting perspective that we had talked about before, where at times you're representing tenants, at times you're representing landlords. How evolving, how changing a field is this, especially in the era we're living in now, the COVID era?
Mm-hmm. Very much changing. I think the practice of landlord-tenant is changing day by day as the courts are still backlogged and figuring out how to deal with cases. The procedures are changing. The law is changing itself with the administrative orders, the governor's orders, the court orders, the practice tips, the practice orders. Really, every day is different. The courts being backlogged, which is unprecedented. It's different. The practice itself is different because the courts are backlogged. So getting on the court's calendar is different than it used to be, which was automatic.
How backlogged are the courts?
Thousands and thousands and thousands of cases. I tell people that once, I'm sorry?
I said, wow.
I tell people that once you file, it used to be that once you file, you would be in court in 10 days. At this point, there are cases we filed a year and a half ago that still don't have court dates. I mean, and it gets more complicated as to why, right? Certain cases are deemed emergencies, certain cases are deemed non-emergencies. Certain cases are get ahead because there are two lawyers. There's a lawyer on both sides. Then you have the court dealing with not having the tenants. If you're representing landlord, not having the tenant's email address or a way to contact them, as we were doing the Zoom method and the virtual method. If you don't, if the court doesn't have an email address for the tenant, then what do you do? So it's really logistically a nightmare because not everyone has internet, right? So how do you, equalize how people get to court? How do you get to someone who doesn't have an email address? while you're doing Zoom court, right? So it's logistically very, very hard.
Is there any thought, has any thought been given? Has there been any movement toward the idea of sessions taking place back in the old-fashioned way in an actual courtroom?
Absolutely. Absolutely. And of course, attorneys complain that way too, because we got used to not going to court, right?
Right.
We got used to not going to court. So for us, for a lot of us, it's working. For older attorneys, it's very, I say older, for me, for anyone, right? It's better to obviously be behind your desk and take, a couple of court appearances as opposed to traveling and waiting hours in court. So most attorneys don't want to go back to the old style, I would say. But how do you do a trial online? They are happening, but how do you accommodate the CPLR and evidence and all these things? There are ways, but it's evolving as we deal with the technology. But yes, tenants are being allowed back in court to file their cases and to appear. Some of it is a mix. Some appearances are mixed between one party's at home or virtual and the other party's is in the courthouse. So how do you really negotiate that? Technology will have to prevail.
As you're saying that, I'm thinking, well, wait a minute. I understand that logistically that might make sense in some cases, but couldn't that also open the door to an argument or arguments that there's maybe an unfair advantage to the person who's actually physically in the courtroom in a case like that?
Listen, this is new. This is unprecedented. Yes. And I actually thought about that, at least philosophically, right? Thought about, equal access to justice, right?
Right.
How do you get justice when the tenant doesn't have the internet and you can't really reach them? Does that case get pushed back or not? Those are new times. How do you really deal with that? These are new times. I would say that folks would believe that the person, anyone can walk into the courthouse, right? The issue is the people who really can't, who really don't have the internet access to sit, at home and take the court. So those are considered, I would say, the privileged folks, right? Who can actually do it from the comfort of their warm home. And then you have maybe lower income folks who have to actually travel, right, and leave their jobs and do that. So I think the privilege may be the other way of the folks who can actually easily take court appearances.
Interesting. What is going on with evictions at this point? Here we are, we're coming near the end of the calendar year for 2021. What's realistically happening now?
Mm-hmm. So cases, there are many types of housing court cases. We can get into the weeds, right? But the eviction moratorium is until January 15th, 2022. Folks are wagering whether or not it'll be extended after January 15th. At this point, if a tenant submits a hardship affidavit, then the case usually comes to a halt until the end of the moratorium. Some cases are exempt from the moratorium. They are nuisance cases, right? Wherein the tenant is a nuisance or the occupant is a nuisance, and the case moves forward because a nuisance is affecting the health of the safety of the building. So these cases should be proceeding forward. You do have to, someone has to interpret whether the landlord's allegations are truly truly rise to the level of a nuisance. So that becomes an issue if the landlord believes the tenant's a nuisance, and the tenant comes in saying, I'm not quite a nuisance, I'm a regular case, right? I'm a regular old mill case, so my case should not be moving forward. You haven't proven a nuisance. You haven't alleged enough to rise to a nuisance. So it gets pretty complicated. So there's motion practice, meaning litigation on that, as to whether that case belongs on the calendar or should be struck from the calendar. So this is becoming practice as to what belongs on the calendar, and it can get extensive as to what belongs on the calendar. We do both sides. Landlords and tenants are now very much into challenging hardship affidavits. So tenants are being challenged on whether or not they suffered a economic or health hardship, or would suffer health hardship if they were to be evicted. So that's becoming litigation on its own as to there are hearings and trials on those issues because some landlords don't want to wait anymore for the moratorium. So they're attacking the moratorium on a fact by case basis. So there's tons of litigation that is clogging the court system, right? As to did you truly suffer a hardship during COVID when I see you on Facebook, right? Going to Barbados or going to, right? So landlords are pushing back on what was supposed to be you submit a hardship affidavit and you pretty much have safety during COVID. They are eroding, they are chipping at the moratorium case by case.
Mm. And when we talk about the levels of monies owed, I mean, how extensive does this get?
From my recent statistic, it seems about 15% of people are behind on rent. People of color are more behind on rent, right? I think it's 24% of people of Black people say that they are behind on rent. 15% in total. That's what I'm remembering when I've read. I may not be completely correct. The average seems to be $3,700 owed in back rent. Seems to be about 11 million people say they still owe rent. I know a lot of people, I don't know what it's covering, but I know a lot of people have skipped out on their housing and left, thousands of dollars behind in rent. So does that count as rent or not if you've already left and moved on with rent arrears? We also know that people are not, we have cases where landlords come to us with high-rise apartments and luxury apartments, $50,000 a month case, apartments where the tenant's not paying, right? So I don't know, I don't know if the $3,700 constitutes New York or nationwide, but it seems like New York would have a larger rent gap, rent arrears gap because of the cost of living here.
Wait a minute, hang on for a second, because some of the people who are listening
Mhm.
may literally have fallen out of their seats. There are people, and I think you touched upon this when we spoke earlier, but I just want to make sure I heard this correctly. You're saying that there are people in $50,000 a month apartments
Correct.
who are not paying any rent.
Correct. Correct. I've been approached by landlords who say the tenant owes 200 grand. How long has it's 4 months of arrears? How does that work? The tenant's a doctor, right? The tenant is the tenant is well known. Like it just there are all types of tenants who are seeking protection, the protections of the moratorium.
Wow.
Luxury apartments are not excluded. It's not really lower income or middle income people. It's everyone submitting hardship declarations, hardship affidavits, because I don't know that the law made a really determine what was a hardship, right? We're all suffering some type of hardship. So that becomes what is a hardship? What is a hardship, right? Most people did lose some income or paying more towards something, right? So these folks are taking advantage of that looseness in the law to say, I've also suffered a hardship. I may be well off, but I have suffered hardship during COVID.
Wow. Interesting discussion we're having on our program. Our guest is someone who's spoken with us previously. Altagracia Pierre Outerbridge is talking with us on our program. She's founder, owner of New York City-based law firm Outerbridge Law PC. And she's kind enough to talk with us on our program. Her practice is focused on landlord-tenant litigation and transactional matters, as well as immigration cases. And we're talking in the first portion of our discussion about this issue of evictions, what exactly is taking place in terms of the federal eviction moratorium, how this is playing out. For landlords, I guess the question becomes, especially in the cases where they're owed thousands of dollars, or tens of thousands, or I guess in some cases even hundreds of thousands of dollars. Where do they turn?
So there has been allocated for about $47 billion towards eviction prevention. What I know is about 10 or 17%. I don't have the direct percentage, but less than 25% has been distributed. So there is money out there. The efficiency of the states distributing, it's been from the federal government and the states alike. The efficiency of the states distributing it has not been great. But there is money out there. There are two, there's in New York at least, there's ERAP, Emergency Rental Assistance for Current Tenants, and there's LRAP, Landlord's Rental Assistance, which is a smaller sum, a smaller amount for landlords who apply for tenants who refuse to apply, right? Some tenants refuse to apply and don't believe the landlord should get paid, right? So the LRAP is for the landlords to apply themselves when the tenants refuse to apply or the tenants have vacated. So there are ways, but it's very much the ERAP, which is the larger pot of money in New York, is led by the tenant applying.
Hmm. It sounds like a very complicated situation, and one that it also sounds like there's so much that potentially is open to interpretation. I mean, how do you keep on top of all the changes that must be going on, realistically, almost on a daily basis?
Absolutely. So I think I mean, we're all human, right? Everyone, you you read the law as it comes out. Cases are coming out, right? They're published. You read the cases, you attend the meetings, the practitioners' meetings. You practice law, right? You appear in court on your cases as prepared as you can possibly be, and you zealously advocate. And most judges are good at what they do, which is mediate disputes, right? And not have it be on the calendar if it doesn't have to be on the calendar, right? So disputes get mediated by very good mediators, which are the judges. You appear and you try to settle the dispute, and if it cannot be settled, then you prepare for trial, for a hearing, whenever that is. But judges are trained to settle disputes. But in terms of changes that are done every day, you can call the clerk's office, right, and ask. You can, I mean, the resources are out there to, right, and it's just practicing law.
But I mean, you realistically though, you must spend hours online trying to follow up on
So
what all these areas are, what's happening in specific cases, the kind of nuances that there must be associated with these cases. It seems like it'd be mind-boggling just to try to keep up with this.
So in terms of landlord-tenant, the New York Law Journal publishes cases every Wednesday and Friday on landlord-tenant. So there are days where they publish cases, and those are the cutting-edge cases.
Okay.
I mean, if that's one, right? That's one way as the cases are coming out. Not all cases are posted or published, but if they are published, that means the New York Law Journal, which is a premier law journal, found that it was unprecedented or unique. So reading that will keep you abreast of what the judges are doing. And those are usually cases decided within the last couple of months or a couple of weeks even. There's a massive, I mean, there's research out there, right? Case law, Westlaw, Lexis, which is our research engines where you put in your issue and you research it. Right now, I don't know how much it helps because this is all unprecedented. So judges will say, I know that this was decided in another jurisdiction, but not mine. What is your opinion? Why do you think I should follow this jurisdiction versus the other jurisdiction? So all of it is unprecedented. Folks are calling saying, what will happen to the commercial tenant in this context? All of it is being decided whenever the courts fully reopen. New law will be made as to this disaster, this catastrophe that we're still going through.
Here we are at this time of the year too, where we get into this whole idea of the New York City heat season, and at the core of that discussion, I guess, is getting into the idea of the New York City heat law. What exactly does that law state?
Mhm. So tenants are entitled to heat. So those are the calls we start getting around this time of year. Tenants are entitled to heat, or around October, really. Um, and usually, even in before COVID, this was an issue. Now it's becoming more and more of an issue, right? As landlords are not getting paid. Keeping heat on is expensive, right? Boilers cost a lot of money to replace. The heat law says that between during the heating season, which is October 1st to May 31st, you have to keep the apartment at 68 degrees if outside is below 55 degrees, and 62 degrees at night. So that's what keeps landlord tenant attorneys busy during this time of year, which is tenants saying, I don't have any heat, right? And landlords trying to give as little heat as possible. But that's the fodder of litigation during the winter for us.
Now, when we're talking about at night, night is specifically defined, as I recall in reading up on this. Basically, it is from what, 10 at night until 6 in the morning? Is that right?
Correct.
Okay. All right. So we get into some things that I would think naturally come up as questions. So let me pose a couple of these to you. And one of the ones that I would think naturally would come up is, if the New York City heat law is not being followed, can the tenant withhold the rent?
Absolutely. So absolutely, the tenants will often call us and say, I read online that I can withhold rent. That is a very complicated decision, because what it usually leads to is you being sued for non-payment of rent, right? So folks believe that if they read online that I can withhold rent for lack of services, then I clearly I'm gonna get what I'm gonna be found to be right, because there were truly no services. Landlords don't respond that way. They sue you for non-payment, even if they know they're not giving heat. So I usually tell tenants, although you may be right, withholding rent comes with pros and cons. It does put pressure on the landlord, but the consequences are that you are going to be sued, which for some people is fine. For some people, they struggle with the idea that you could not provide services and then have the nerve to sue me on top of it for non-payment when I withhold. Folks believe that the right to withhold rent is absolute if you're not giving services. It's very much litigated. Landlords will sue you for non-payment, and at that point you will be in court trying to prove your case. And proving lack of heat is very, very complicated in terms of keeping your log of heat every night, right? Which is what most people don't want to be doing, that when they come home from work, right? Or spending time with their families, right? Keeping a log of heat, keeping a notebook and testifying, right, as to what the heat, what the temperature was inside, how you took the temperature, right, whether your method of taking it was correct. This gets very, very complicated as to proving your actual case. So usually these cases will settle with some type of a small abatement, and never what the tenant believes that they're entitled to, because lack of heat is very uncomfortable, but it's not absolute, because you will be in court spending more time trying to prove that there was no heat, and the landlord will usually deny that this was the case.
So what does someone do if they don't have heat and hot water?
So I always tell people to get as many violations on their building as possible, because violations, I say, is 80% of the battle. Once a city finds a violation, then it's pretty much real, that what you said is real. Um, I also ask people, the next step before you get sued, I would say, to sue the landlord for lack of services. That puts the landlord on the defensive, because instead of being on the offensive for withholding rent, at which point you would be sued in a non-pay, putting the landlord on the offensive by suing them for lack of heat, makes them do it without you being on the defensive. It's called an HP action. For lack of services, it's very easy to start, and then you likely will be in court. Lack of heat, lack of hot waters are considered emergencies, or time sensitive at least, so you will be in court faster than other violations, right? And then the landlord would have to, usually those cases are very effective. The landlord would have to prove that they're giving heat and hot water. What I tell people to do is to not just withhold rent and wait and think that withholding rent and sending an email to the landlord will change anything, right? If you're not pushing litigation and trying to push the landlord back, the email doesn't quite mean much to landlords, right? Saying I don't have, that doesn't do much. They'll just sue you for non-payment. Right.
Well, when it comes to that time when the decision's being made to sue the landlord, does the tenant that's involved in this need other tenants to do so?
So that's a great point, that which I was going to mention. So it's called a tenants association. There's always more power in numbers, and folks usually call, especially with lack of heat and hot water. They usually call and say, if I get others to join, that's great. It's absolutely great to get others to join. And we always push for that when folks call us. What I say to people, the other side of, I have no cons, except that the con is you have to be organized to maintain a tenant association. A group of people has to be organized to actually be effective. So having 3, 4, 5, we have tenants associations that are 2 people, right? So I've represented tenant associations that were 20 people, 20 tenants, right? 20 different apartments in the building. The issue becomes folks are not on the same economic footing. And how do you pay the attorney? How do you compensate the attorney? Who pays the legal fees? What is, who uses the time of the attorney? So that becomes an issue in and of itself in terms of the organization of the tenants association and putting forward what the group wants to do with their legal fees, how they want to spend it. So usually that comes with some conflicts between people. And often when folks realize what comes with having a group of people represented by one advocate, they realize that it takes a lot of work. Is it worth it? Yes. But then you would have to realize that you need a common goal, right? Some apartments will have heat at times and some apartments won't. And who's spending them, who's calling the lawyer, who's not calling the lawyer. So that usually results in some conflict.
What about contacting 311 to report the violation?
Sure, 311 is great. So that's that's HPD, right? That too, yes. So HPD, that's the really the very first method, and that method should continue. Very, very first method. So it's 311. 311 has its own pros and cons, right? I would say it's not quite a con, but they will come when they will come, right? You don't quite get a date when 311 will come, when the inspector will come. So folks will usually, at least before COVID, would be at work, right? And 311 would show up, right? So getting to meet that inspector is probably easier during COVID as folks are working from home, but there's still some hit and misses as the inspector comes and you're not home. Or not available to give access, so that they can actually measure review the conditions in your apartment. But 311 is a big part of the game. I would say it's 40-50% of the game in terms of getting the landlord to respond and give you services. Again, the next step would be to bring a case as a group. And I'm not sure that it's made as simple as possible by the court system to bring a case as a group, to bring a case for repairs. Ultimately, the landlord will be represented. Most landlords are corporations, which means they have to have an attorney. So you are still going against an attorney, right, who actually knows the court system and knows how to, is practicing law against you. So it's always it's not an equal playing field. But the more people, the better, so long as the group is organized and is aware of how they want to move forward together in terms of being in court.
And how do you recommend the tenant contact the landlord? The old school way, by phone or email, or just what?
It's funny. It's funny because folks will tell me I've emailed the landlord. In the end, most leases will say that the method for notice. And folks never really review that because leases are mostly antiquated and they will say certified mail. Some of them will say registered mail is proper notice. And even some attorneys would, so folks have moved on to use email all the time. I know very few landlords, I'm not going to say very few, but less and less landlords will pick up the phone, right? There's someone usually, but most landlords are using, so I'm going a little bit different direction at the same time. Most landlords are using, the larger landlords are using a portal where you can report your repairs, right? However, your lease is still saying notice has to be done by certain mail or registered mail. So I always tell folks that while you're sending all these emails, which is constructive notice, your lease still says what it says.
The guest is Altagracia Pierre Outerbridge. She's the founder, owner of New York City-based law firm Outerbridge Law PC. She's kind enough to be talking with us about a number of topics. I'm Bob Salter, and she's joined us previously on our program. We had an interesting discussion then, so pleased to have her back and speaking with us today. One of the areas where I wanted to go before we wrap up in our discussion with you is getting into talking about exactly what's going on with rents in Manhattan, especially because they seem to be just going through the roof. Is it true that this is literally at the fastest pace on record now?
Absolutely. So folks left the city in a rush and folks are coming back in a rush. I mean,
Right.
we know that the city will always be in vogue, right? New York City will always be in vogue, whatever time we're in. But folks left in a rush to go to the suburbs and folks are coming back in a rush. So yes, it is the fastest pace. The rents are going back, trying to make up for old times.
So, you know, last year there was the case where it seemed like a whole lot of people were used the phrase from the old west, trying to get out of Dodge, basically, as quickly as they could with the COVID and heading to the suburbs. I mean, I understand that the city is popular, it's in vogue and all, but how much are these rents really rising, and how are people affording this?
Mm-hmm. It's always interesting to me how people afford rent. Again, we have tenants who pay 50 grand a year in rent. We have clients who pay that in rent. Not a year, a month. We have clients who pay 40 grand a year in rent, right? We have clients who pay $170 a month, not a year, a month. Each of these is a monthly amount. We have
Right.
clients who pay, who are rent controlled or rent stabilized, who pay $170 in rent, right? How are folks able to afford it? We know that first you said how much are the rents going up, right? So as I'm reading this now, it's saying that the rent rose a full 25% year over year, which is shocking to me as a tenant attorney. How are folks affording it? We're finding that the younger folks are coming together as we have a lot of roommate situations, a lot of college students, a lot of younger folks who haven't started families or maybe have, right, who are living together, right? The roommate situation that comes with its own problems, as a roommate may choose not to pay rent and you still are saddled with that rent. How are folks affording it? I'm not really sure. I'm not really sure. I know that the rent burden is high and folks expect that half their salaries go to rent. So they do exactly that. They put their salaries towards rent.
It's also interesting because you have some of the largest employers in Manhattan who they're not hiding the fact that a lot of them are planning to reduce office space, cut staff. I mean, this is kind of an outgrowth of the whole thing with COVID, is they are seeing that they don't need to shell out all this money for office space, and they're able to do things they feel more efficiently with less people. Naturally, they're going to look to reduce costs in that fashion. But it's an interesting irony that at the same time that's taking place, the rents in Manhattan are just skyrocketing too. And the other
I
thing
mean,
is, I'm
go
sorry.
ahead. Go ahead. No.
The other thing I'd read is that the actual sales in Manhattan also have like jumped greatly. Like the co-op contracts and new condo contracts apparently are surging also.
Absolutely. I mean, Manhattan is Manhattan. Manhattan will always be Manhattan, right? So folks are paying a premium to live here. That's the sacrifice I'm guessing that they're making. But yeah, it is very much a seller's market in terms of that too. The rents are high and folks are paying them. I've had situations with 4 or 5 roommates in an apartment, right? People are putting money together to live in the city. Then I've had situations where folks are maybe not paying other bills, but they're paying the rent, right? Then some situations you wonder, why would you pay $4,000 in rent, right? When it's not feasible, but folks make that decision.
Mhm. Okay, now the other area where I wanted to go before we finished in our chat with you today. And this gets into this whole idea of masks, vaccines, etc. The big question is, can a landlord or can a homeowners association force residents to wear a mask or get a vaccine?
So I don't know about the getting the vaccine part, but very much so. I mean, at least in my building, in most buildings, you'll see a sign that says you're required to wear a mask. Landlords are businesses, right? And businesses are required to enforce this. The issue becomes that landlords are not able to tell who's vaccinated or not, right? So who should wear a mask, who shouldn't? And I think it's really most landlords have other things on their plate, including obviously non-payment of rent, right, for many tenants, and to push this forward. I think ultimately enforcement of that is very difficult. So I don't know of any landlord who's really enforced a mask requirement, although the notices are obvious out there in the elevators, in the common areas, that people should wear masks if they're not vaccinated. The issue becomes, how do you tell if somebody's vaccinated or not? You likely won't be able to know. And the issue second becomes, is this what a landlord is really worried about right now, right? The third issue is, most landlords are really responding to tenant concerns, right? So if tenants are not making a fuss about mask wearing, then landlords are, they're in business to make money, right? They're not worried about it either. Ultimately, most tenants will police each other in terms of mask wearing. I mean, you get the side looks. Somebody's not wearing a mask, and there probably will be a side look that would police that other tenant. But ultimately, landlords are not quite able to enforce it. I've seen in cases that my firm has participated in or represented a litigant, where landlords are going after the worst offenders, right? Folks who have, there was a famous case, I don't want to reveal too much because it would tell who my client was, but where the tenant was having very large parties, right? Large parties during COVID, the summer of all things, without masks. So landlords are spending their money on the worst offenders, and only when other tenants are complaining, because the failure of the landlord to push the mask requirement, if other tenants complain, means that those tenants may not pay rent, right? Because they may withhold rent for lack of, for the landlord not taking enough action to protect them. So I've seen it pushed both for and against our clients in cases where the tenants having, massive gatherings or frequent gatherings. Often it's a famous tenant, right, who has a lot of guests, right? Or a tenant who has a club, a club in their home, right? Is doing parties for money. So those are the cases where the landlord will actually spend money and try to get an injunction in court. So I've seen many injunctions in that way, where there's an injunction forcing the tenant to abide by the law. Usually in Supreme Court, where the landlord will say, this has been happening. I'm seeking to enjoy the tenant from breaking the law, right? On the CDC guidelines, and having masks and following the rules. But usually it's the worst offenders only, not the regular, family that goes into the elevator with no mask.
Right. So legally, are landlords required to follow and actually enforce the CDC guidelines?
I would say maybe. I'm leaning more towards yes. I've read it all. I've read it all in my research. I'm leaning more towards yes. Again, the enforcement, there's no enforcement there. How do you enforce that? How do you
Right.
know if somebody is vaccinated or not? No real way to know. No real way to know.
Hmm.
So ultimately, landlords, I think they have other things on their plate, right? Yes, they'll put the signs up saying if you're not vaccinated, honor system, please wear a mask. But otherwise, there's no real way to know.
Mm. And the natural question that I'm going to pose to you, because I've thought about this and wondered what the reality is. Can a resident or residents sue a landlord or landlords if they wind up going down with COVID with the claim that it was from unvaccinated tenants?
Bob, I've seen a lot of stuff in my legal career, right? I guess you can bring any case you want. I don't know of a personal injury attorney that would take that type of case because you would have to prove
Hmm.
causation, right? That your illness, right? Your the wrong that was done to you was caused in this chain was caused by the landlord's negligence. So I don't see an attorney taking it. Again, I've seen people bring all types of cases. I don't see an attorney taking it, but if they were, you would want to know what damages they suffered, right? Because it's not just that you were wronged, it's what damages you suffered as a result of being wronged. Um, I don't see this case succeeding, but I'm sure it's going to be something that comes up.
Mm. Altagracia Pierre Outerbridge, our guest on our program today. She's founder, owner of New York City-based law firm Outerbridge Law PC. Very kind with your time and sharing some thoughts with us. For people who are interested in perhaps finding out more about the work that you do, I mentioned the fact that your firm focuses on landlord-tenant litigation and transactional matters as well as immigration cases. How do they reach you?
Oh, easy. 877 Outerbridge. 877 Outerbridge, outerbridgelaw.com.
Thank you very much for joining us on our program. Certainly stay well and best of the holiday season to you.
Thank you so much.